Good afternoon. Welcome. Glad to see so many folks here. I'm Jonathan Adler. I'm a professor here at the law school, and it's really my pleasure and honor to welcome all of you to this year's Sumner Canary Memorial Lecture. This is perhaps the law school's premier endowed lectureship. It was established in the honor and memory of the late Judge Sumner Canary, who was both a judge on the Ohio Court of Appeals for the 8th District, a U.S. attorney, as well as an active member of the bar locally. And this lecture was made possible by a generous gift from Nancy Canary, who's with us today, and we certainly appreciate her support of this series. This lecture really has a distinguished history over the last, I think, 39 years. If I'm counting correctly, it's hosted Justices Sandra Day O'Connor, Warren Burger, and Antonin Scalia. More recently, it's hosted Judges Diane Sykes, then Judge Neil Gorsuch. His lecture from this series is included in his just released book. Then Judge Brett Kavanaugh, Bill Pryor, and attorneys such as Neil Katyal. Last year, we were honored to host the Honorable Joan Larson, who sits on the Sixth Circuit. Her lecture was just published in the Case Western Reserve Law Review. I believe there are copies out front for those that are interested in her lecture. This year, it's really a great honor to be able to introduce to you the Honorable Amy Coney Barrett, who sits on the U.S. Court of Appeals for the Seventh Circuit. She's a graduate of Rhodes College and the University of Notre Dame Law School. After law school, she clerked for Judge Lawrence Silberman on the U.S. Court of Appeals for the D.C. Circuit and for Associate Justice Antonin Scalia on the Supreme Court. After a few years in private practice, she returned to Notre Dame Law School, where she was, among other things, the Diane and M.O. Miller II Research Chair in Law, was twice named the Distinguished Professor of the Year, and as I understand it, continues to teach the occasional class or seminar at the law school. She was named by Chief Justice John Roberts to the Advisory Committee for the Federal Rules of Appellate Procedure and produced an impressive array of scholarship on a range of issues, including the role of precedent and issues of constitutional interpretation. In November 2017, she was confirmed to the U.S. Court of Appeals for the Seventh Circuit, where she has sat ever since. I know none of you are here to listen to me, so I will get out of the way and turn the podium over to Judge Barrett.
Thank you for Professor Adler, and thank you, Mrs. Canary, for the generous funding of this lecture. I am delighted to be here. It would be an honor to speak to you at any time, but after Jonathan invited me to give this lecture, I looked back at past lectures and realized that this is the 30th anniversary of the lecture that Justice Scalia gave, the Canary Lecture. And Justice Scalia is my former boss and mentor, so I am particularly honored to be delivering the lecture on the 30th anniversary of the lecture he gave to you at the same event. His lecture was called Assorted Canards of Contemporary Legal Analysis. And that lecture described his most hated legal canards. He described them as baseless but frequently repeated statements that lawyers are condemned to read again and again in the reported cases. He took aim at the hoary canon, remedial statutes are to be broadly construed. As he said, how do we know what's a remedial statute? Aren't all statutes trying to remedy some social problem? And why should we construe any statute broadly? All statutes should not be construed broadly or narrowly, but rather at the level of generality at which they are written. He also bemoaned the well-worn phrase, a foolish consistency is the hobgoblin of little minds. As he put it, why is consistency in the law a bad thing? Kind of what we're going for. So tonight, in the spirit of Justice Scalia's Canary Lecture, I thought I would share my own list of canards. Here is my first. Textualism is literalism. Before I explain why this is false, I ought to begin with a brief definition of what textualism is. Textualism is a method of statutory interpretation, and it is associated closely with Justice Scalia, who was one of its most vocal proponents. Textualism insists that judges must construe statutory language consistent with its ordinary meaning, the meaning that it would have had to a skilled user of the language at the time he or she heard it. The law is comprised of words, and textualists insist that words mean what they say, not what the judge wishes that they would say. For textualists, statutory language is a hard constraint. Fidelity to the law means fidelity to the text as it is written. Textualism stands in contrast to purposivism, a method of statutory interpretation that was dominant through much of the 20th century. For purposivists, statutory language is not necessarily a hard constraint. It's important. I don't want to caricature purposivism. It's important, to be sure. But as one famous Supreme Court case put it, a thing may be within the letter of the statute and yet not within the statute, because not within its spirit nor within the intention of its makers. In other words, sometimes statutory language appears to be in tension with the statute's overarching goal. And when that happens, purposivists maintain that a judge should go with the purpose, go with that goal rather than the text. Today, purposivism is largely out of fashion, at least in its more extreme forms. It was once unsurprising to see a judicial opinion stress the importance of adhering to a statute's purpose, even at the expense of a clear text. Now, however, it's rare to see a judicial opinion asserting the authority to depart from the statutory text in the service of statutory purpose. The shift away from purposivism and towards textualism is largely due to the force of Justice Scalia's arguments. As he put it, it is the law that governs us, not the intent of the lawgiver. Men may intend what they will, but it is only the laws they enact which bind us. I won't rehearse all of his arguments against purposivism here, but suffice it to say that they've had a significant effect on the way that judges think about the law, lawyers too. The fact that textualism has become influential, however, does not mean that everyone understands what it means to be a textualist. And by the way, this includes people who are sympathetic to textualism as well as those who criticize it. One misunderstanding held by textualism sympathizers as well as by some of its critics is that textualism is literalism. Some who have only a passing familiarity with the theory assume that textualism requires judges to construe language in a wooden, literalistic way. And that, of course, would lead to absurd results. If you want a vivid illustration of the dangers of literalism, consider the pitfalls of translating from one language to another. When I was in college, I spent a summer in France, largely with the goal of becoming fluent in French. One evening at dinner, my host asked me if I wanted more food, to which I responded, translating from English to French in my mind, literally, je suis pleine. That means I am full, literally. I was quite proud of myself for being able to respond in French, but my sentence was greeted with uproarious laughter. And it was not, as I initially assumed, and as one of my French professors in college criticized me for once, for speaking French with a distinctive southeastern Louisiana accent. I'm a New Orleanian. It was much worse than that. I learned that in French, the phrase je suis pleine means I am pregnant. Not what I intended to convey. One could make a similar gaffe by declining food with the phrase je suis fini, which literally means I am finished, but in French, this phrase means I am finished, as in I am about to expire, which is kind of what I wished would happen when I said je suis pleine. As a budding French speaker, I was unaware of the nuance. Language is a social construct that's made possible by shared linguistic conventions among those who speak a language. Language just cannot be understood out of context, and literalism strips language of its context. As my examples illustrate, fluent speakers of language are not literalists. There is a lot more to understanding language than mechanistically consulting dictionary definitions. Textualists understand this, and they have spent more than 30 years driving home that point. Justice Scalia himself insisted that a good textualist is not a literalist. Still, textualism and literalism are often treated as synonyms. I will say, as Professor Adler mentioned, I continue to teach at Notre Dame, and I teach a seminar in statutory interpretation. And almost every year, at the conclusion of the class that we spend discussing textualism, I ask students if anything surprised them or if they had preconceptions that their minds were changed about as a result of the discussion. And overwhelmingly every year, the number one thing is, oh, I thought textualism was more like literalism or strict constructionism. It is one of the primary misapprehensions about what textualism is. And the distinction between these two things, textualism and literalism, is fundamental to the validity of the textualist enterprise. Here is how one scholar distinguishes the two. Literalism should be distinguished from the genuine search for textual meaning based on the way people commonly understand language. Literalism is a kind of spurious textualism, unconcerned with how people actually communicate, with how the author wanted to use language, or the audience might understand it. It holds up text in isolation from actual usage. Collapsing the distinction between textualism and literalism is a straw man when presented by critics of textualism, and it's a dangerous imprecision when it's floated by textualists themselves. They are not the same thing, and that is the first canard that I want to stress today. But this rejection of literalism bleeds right into the next proposition that I'd like to shoot down. A dictionary is the textualist's most important tool. Don't get me wrong, dictionaries are useful, and interpreters of all stripes use them. But because textualism is not literalism, textualists do not come to the enterprise of statutory interpretation armed only with a dictionary. That is, however, a somewhat common caricature because it ties back into that whole textualism as literalism canard. John Manning, who is a prominent academic textualist and now the dean of Harvard Law School, explains this. Dictionary definitions of words will often fail to account for settled nuances or background conventions that qualify the literal meaning of language, and in particular of legal language. A dictionary can help, but it can't get you all the way there. Justice Scalia frequently invoked the case Smith versus United States to make this point. In that case, the Supreme Court was faced with the task of deciding what it means to use a gun. This was for purposes of 18 U.S.C. Section 924C, the felon in possession statute, and among other things, it makes it illegal for felons to use guns. The majority of the court, and Justice Scalia was not in the majority, cited multiple dictionary definitions of the verb to use, concluding that, as dictionary definitions and experience make clear, one can use a firearm in a number of ways. And use is a quite capacious word, right? Use can encompass a number of different things. Here, the question was whether a felon used a gun when he traded that gun for drugs. So he used the gun as currency. In dissent, Justice Scalia explained that just because a word can be used in a certain way, consistently with a dictionary definition, does not mean that it is ordinarily used that way, or that it was used that way in that particular context. In his view, the majority's reliance on multiple broad dictionary definitions of what the term use could mean violated the fundamental principle of statutory construction, and indeed of language itself, that the meaning of a word cannot be determined in isolation, but it must be drawn from the context in which it is used. In typical fashion, he offered a memorable illustration to bring his point home. When someone asks, "Do you use a cane?" he is not inquiring whether you have your grandfather's silver-handled walking stick on display in the hall. He wants to know whether you walk with a cane. Similarly, to speak of using a firearm is to speak of using it for its distinctive purpose, i.e., as a weapon. When we say, "Do you use a gun?" or "Did he use a gun?" we think of using it for its intended purpose, just as we might say, "Do you use a wheelchair?" or "Do you use a cane?" We're speaking of using that object for its intended purpose. None of this is to say that dictionaries are useless. It's simply a warning against overstating their utility. Dictionaries should be used correctly as evidence that terms can in fact bear a certain meaning, but they are not the smoking gun evidence identifying what a specific term means in a given context. The upshot here is that textualism is not about holding language in isolation from actual usage. It's not about taking things out of context. It's not about strictly construing language that isn't strict. It's about identifying the plain communicative content of words. A text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably to contain all that it fairly means. I hope I've made it clear by now that textualism is not a mechanical exercise, but rather one involving a sophisticated language as it is actually used in context. That principle brings me to my third canard. Textualists always agree. Those who take an oversimplified view of textualism imagine that it works like Google Translate. A judge punches in words and voila, out pops the result. And if that's how interpretation works, one could reasonably expect every textualist judge to interpret in exactly the same way and to get the same result when they approach a problem of interpretation. Popping words into a mental machine, after all, doesn't require judgment. Construing language in context, however, does require judgment. Skilled users of language will not always agree on what language means in context. Textualist judges agree on the fundamental principle that we interpret words in accordance with their ordinary meaning, and that when it is determinate, that meaning constrains, that judges cannot depart from the meaning of the text. That does not mean, however, that they always agree what the words mean. In a case that preceded my time on the Seventh Circuit, two of my colleagues on the court, both of whom are very avowedly embrace textualism, disagreed about whether Title VII, which prohibits discrimination on the basis of sex, prohibits discrimination on the basis of sexual orientation. So Judge Frank Easterbrook joined the majority, which held that it does, and Judge Diane Sykes wrote a dissent arguing that it does not. Neither disavowed the text, neither disavowed his or her respective commitment to textualism. They simply disagreed about what the text meant. The same holds true for originalists. Textualists in statutory interpretation tend to be originalists in constitutional interpretation because the two theories approach text similarly. Originalists maintain that a judge must be faithful to the original meaning of the enacted constitutional text, the ratified text. Justices Scalia and Thomas are both well-known originalists, yet they did not agree in every case. Differences between Justices Scalia and Thomas have permitted my friend Judge Amul Thapar of the Sixth Circuit to teach a class at the University of Virginia Law School that he colloquially describes as Scalia versus Thomas. Here's an example of a case in which those two justices diverged. The case is called Brown versus the Entertainment Merchants Association. In that case, Justice Scalia held that violent video games qualify for First Amendment protection because the limited exceptions to the First Amendment, obscenity, fighting words, etc., cannot be expanded, and California's law, which limited access to violent video games, failed strict scrutiny. Justice Thomas dissented. He argued that the court's decision today does not comport with the original public understanding of the First Amendment. The practices and beliefs of the founding generation, he said, establish that freedom of speech, as originally understood, does not include a right to speak to minors or a right of minors to access speech without going through the minor's parents and guardians. I would hold that the law at issue is not facially unconstitutional under the First Amendment. Originalists don't always agree, just like textualists don't always agree. On the current court, Justices Thomas and Gorsuch have been the most vocal about their commitment to originalism. They don't always agree either. Just last term, they split in Gamble versus United States, a case that validated the so-called dual sovereignty doctrine of the double jeopardy clause. That doctrine means that two offenses are not the same offense for purposes of the double jeopardy clause if they are prosecuted by separate sovereigns. Thus, the federal government cannot prosecute someone twice for the same murder, but the double jeopardy clause does not prevent the federal and state governments from each prosecuting someone for the same murder. Where there are two sovereigns, there are two laws, and therefore two different offenses. That's what the majority said. Justice Gorsuch dissented from that holding on the ground that the dual sovereignty doctrine is inconsistent with the original meaning of the Fifth Amendment. Justice Thomas was in the majority. In his concurring opinion, this is what Justice Thomas had to say. The historical record does not bear out my initial skepticism of the dual sovereignty doctrine. The record presents knotty issues about the meaning of the Fifth Amendment, and Justice Gorsuch does an admirable job arguing against our long-standing interpretation of the double jeopardy clause. Although Justice Gorsuch identifies support for his view in several post-ratification treatises, I do not find these treatises conclusive without a stronger showing that reflected the understanding of the Fifth Amendment at the time of ratification. All of this is to say that even card-carrying originalists do not always wind up at the same spot. And it is a caricature and oversimplification to suggest that they would. Here's my next one. We must never forget it is a constitution we are expounding. But wait, Justice Marshall, the great Chief Justice John Marshall said that. Why is it a canard then? In his Canary Lecture 30 years ago, Justice Scalia identified and attempted to correct the misuse of that quote. It's one of Chief Justice Marshall's most famous quotes, and it appeared in McCulloch versus Maryland. We must never forget that it is a constitution we are expounding. Justice Scalia explained that this quote is often trotted out nowadays to make the point that the Constitution does not have a fixed meaning, that it must be given different content from generation to generation, retaining the flexibility needed to keep up with the times. Those were Justice Scalia's words. In his view, this reading of Chief Justice Marshall's language is exactly backwards. Rather than sanctioning judicially guided constitutional evolution, the McCulloch quote was simply an acknowledgement that it is the nature of a constitution not to set forth everything and express in minute detail, precisely because it is a fixed document that's intended to endure through the ages. And if it was weighed down with the prolixity of a legal code, it wouldn't last. It would become quickly outdated. So Justice Scalia, in his Canary Lecture, invoked that quote to make the point that the McCulloch quote offers no support for a theory of an evolving or living constitution. I want to make a different but related point today. I want to argue that McCulloch offers no support for the idea that the Constitution should be interpreted differently than other legal texts, that somehow the Constitution is not itself a legal text as opposed to simply an aspirational one, or one that gives judges a common law charge. After all, the Constitution is, at base, a democratically enacted written law. And therefore, our approach to interpreting it should be the same as it is with all written law. In other words, that it should be interpreted consistently with the meaning that it would have had to skilled users of the language at the time that it was ratified, and that its words bind, that judges are not free to depart from the meaning when that meaning is determinate. Now, I willingly concede that no matter how one reads that phrase, we must never forget that it's a constitution that we are expounding. Chief Justice Marshall surely meant to communicate that our Constitution is unique, and he is surely right. None of our other written laws purport to lay out an entire system of government that is meant to endure throughout the ages. That singularity often manifests itself in expansive phrasing and in broad delegations of congressional and executive authority to address unforeseen circumstances. But as Justice Scalia explained elsewhere, the problem of interpreting the Constitution is distinctive, not because special principles of interpretation apply, but because the usual principles are being applied to an unusual text. The text itself remains a legal document, subject to the ordinary tools of interpretation. Due in large part, I'm sure, to Justice Scalia's contributions, the idea of approaching the Constitution like any other legal text has gained not only traction but force in judicial opinions. It has also inspired a rich proliferation of scholarship in this area. For example, two scholars have emphasized that any project of constitutional interpretation that seeks to apply the Constitution as law must reckon with the fact that it is a written text that the Constitution purports to make authoritative. And judges take an oath to be bound by that written text. What does that oath mean? What does it mean to be bound by written law? Well, at the very least, it means that the meaning of law is fixed when it is written. This is a largely, although not entirely, uncontroversial proposition when it comes to statutory interpretation. Textualists and purposivists alike are both inclined to ground their approaches to statutory interpretation in the concept of faithful agency. The idea that they are giving voice and authority to what Congress did when it enacted a particular statute. They disagree about how to figure out what Congress wanted, whether one looks to the purpose or the text. But by and large, when it comes to statutory interpretation, even those that employ different interpretive methods take the time of the statute's enactment as the relevant starting point. The textualist approach, however, draws more instruction from the existence of written and enacted law. So as I said before, textualists limit the meaning of text to the semantic communicative content, in context, of the words themselves, not an underlying purpose behind the words, precisely because it is those words that went through bicameralism and presentment. It was those words that Congress enacted and that may reflect some unknowable legislative compromise. It's hard to get legislation passed. There are a number of veto gates at every turn. Things can die in committees. To become a law, something has to navigate all of the procedural complexities in both houses and then either get the president's signature or survive an override of a veto. Honoring that text and honoring the carefully drawn lawmaking process prescribed by the Constitution makes it imperative for judges to respect that compromise. And that means reading the text at the level of specificity and generality at which it was written. And that is so even if the result is awkward or the interpretation does not appear to make perfect sense of the statute's overall policy. That awkward compromise is what made it through the process of becoming law. And in fact, it may have been the compromise that enabled it to succeed that secured the votes that it needed to survive the process. So let's shift back to the Constitution. When we look at the Constitution for what it is, a popularly enacted legal text subject to the same kind of bargaining and compromise over the reach and structure of the policy under consideration, it makes sense that statutory textualists are usually constitutional originalists. The approaches are premised on the same fundamental orientation toward legal text that finds legitimacy in popular sovereignty. Professors Kazavan and Paulson summarize the import of written law this way. We therefore think that to avoid creeping or lurching anachronism infecting the interpretation of an authoritative legal text, the proper approach must be one of originalist textualism, faithful application of the words and phrases of the text in accordance with the meaning they would have had at the time they were adopted as law within the political and linguistic community that adopted the text as law. Originalists, like textualists, care about what people at the time that the words were enacted understood them to mean, because those were the people who had the authority to make law. They did so through legitimate processes, which include writing down and fixing the specific law through the constitutionally prescribed process. So each textual provision must necessarily bear the meaning attributed to it at the time of its own adoption. And as with statutes, the law can mean no more or less than that communicated by the language with which it is written. That is how judges approach legal text, and the Constitution is no exception. I'll return, however, to Justice Scalia's point that it is a unique text. Statutes don't tend to be as old as the Constitution. So there's more distance between the ratified text of the Constitution and then the interpretive problems that we face today. Statutes tend to be much newer. Maybe a statute comes from the 1930s. More often, we're talking about statutes that were passed in the last 20 years. Statutes also use much more precise language. So I don't want to be misunderstood. There's no denying that the Constitution's age makes interpretation more of a challenge, and that the open-ended nature of its language similarly makes interpretation more of a challenge. However, to not engage the original meaning or to treat the text as suggestive rather than binding is to disregard the force of the Constitution and its nature as a legal text, as a law that binds us. So I'll end this particular section where I started, leaving you with a simple but astute observation from Justice Scalia himself. The judiciary is charged with authoritatively interpreting the Constitution because it is a legal text, one that requires the same tools and skills as any other. Were it otherwise, that is, this is a quote from him, if the people come to believe that the Constitution is not like other texts, if it means not what it says or what it was understood to mean, but what it should mean, well then, the people will look to qualifications other than impartiality, judgment, and lawyerly acumen in those whom they select to interpret it. because it's only if it's a legal text that those qualities matter, like impartiality, judgment, and legal acumen. This is a constitution we are expounding, unique in many ways, but at its core, it is a legal text and must be deciphered with the tools of a lawyer. And we should not misconstrue a quote from the great Chief Justice John Marshall as authorization to treat it as anything else. My next canard, I'll be brief. I think my point, however, will be clear. This one is, judicial activism is a meaningful term. It's not. The term judicial activist is thrown around a lot today, both inside and outside of the legal world. People use it all the time with great authority, sure that they know exactly who the judicial activists are. But the problem is that there is no agreed upon definition of what it means to be an activist. There is one thing that is clear, though. It is never a compliment to be called a judicial activist. Sometimes people use the term judicial activism to describe a judge who is willing to hold a statute or executive action unconstitutional. This is kind of the tally approach. One might look at a court, like look at the Rehnquist court or look at the Roberts court, and tally up, this is how many statutes that they've held unconstitutional, or this is how many times they have struck down some executive action as unconstitutional. And if that number is high, they say, oh, this is an activist court, or this is the most activist court in history. On this view of judicial activism, the reasoning proceeds somewhat like this. Judicial restraint means deference to the popular will on this view. It is activist, therefore, to say that the popular will has run afoul of constitutional limits. But here's the problem with this definition of judicial activism. It's been settled ever since Marbury versus Madison that judicial review is part of the judicial function. Everyone agrees that judges, of course, within the limits of their authority, must hold political actors, the popular will, the people, accountable to the Constitution. And so if a statute, be it a federal or a state statute, or if an executive actor, be he or she a governor or the president, does something unconstitutional and a judge is called to make a judgment about whether it's unconstitutional, it is discharging the judicial duty to call a spade a spade. So everyone agrees that judicial review is part of the Article 3 function and that it's part of what judges should do. I haven't heard anyone make any kind of serious argument that Marbury versus Madison and its endorsement of judicial review should be overruled. I think that when people say that a judge or a court is activist, they're not really focusing on the tally. I think if we scratch below the surface, what it really means is holding statutes or executive action unconstitutional when it is not. Or in other words, overreaching, going beyond authority to superimpose the judge's own will on top of the Constitution, and so the judge is then enforcing something other than the Constitution, but rather his or her own preference. I think if we really unpack it, no matter what people say they mean by activism, I think it's really kind of getting at that point. Criticizing misuses of judicial authority is fair game, and we ought to criticize misuses of judicial authority. But we ought to do it on the merits, rather than by resting on the label judicial activism. In other words, we ought to explain why a particular decision is misguided. As David Kaplan wrote in his recent book about the Supreme Court, judicial activism today is really best summed up as what the other guy does. My next canard returns to statutory interpretation. And this is about congressional inaction. So this comes up in my statutory interpretation seminar with my students a lot. They say, well, congressional silence is acquiescence. If Congress doesn't speak, that means it's endorsing whatever it is the judiciary has done. One noted scholar and judge explains the logic like this. When a court says to a legislature, you or your predecessor meant X, it almost invites the legislature to say, we did not. So the theory goes, if a court interprets a statute and Congress doesn't amend or override that interpretation, then Congress's silence is expressing agreement with what the judiciary has done. There are several reasons why this approach makes little sense. To begin with, why should we care what the current Congress thinks about a previously enacted statute? It wasn't the Congress that enacted the statute. Whether you think that what matters is the language of the statute enacted by Congress, the intent or purpose behind that statute, or something else, most theories of statutory interpretation seek to give a statute the meaning that it had at the time that it was enacted. So what a later Congress thinks, even if it is acquiescing, is irrelevant. But even if we did care, there's no way to reliably count on congressional silence as a source of information. There are many explanations other than agreement as to why Congress might not pass a bill to override a court's interpretation of a statute. For one, Congress has to know about the judicial decision before that body can make a collective conscious decision to act or not. And that is not a given. So I think, I would say it's probably an open question whether Congress is aware of all the Supreme Court's interpretations of its statutes, but it's quite doubtful that it's aware of the Seventh Circuit, the court on which I sit, of the Seventh Circuit's interpretations of every statute. Then, even assuming that Congress knows about a given judicial interpretation, that it can keep up with all of the courts across the country and how they're interpreting statutory language, even if it disagrees, it may not want to act. There might be concerns of political expedience. Who bears the responsibility? Is this the best time to act to achieve the best results? What kind of capital will passing a legislation to override this interpretation take? And on and on. But even assuming that Congress knows about the decision, disagrees with it, and wants to invest the capital in responding, political realities might prevent it from doing so. This isn't going to be a news flash to anyone, but passing legislation is hard and resources are limited. I've written about this in my academic days, and as I've said then, numerous obstacles, both procedural and substantive, procedural and practical, hinder the passage of legislation. And so as a result, even a legislature with a majority that vehemently disagrees with a judicial decision may fail to act on that disagreement. So equating the failure to act with congressional agreement reflects a simple and complete misunderstanding of the legislative process. It also reflects a misunderstanding of the separation of powers prescribed by the Constitution. This is one of the most fundamental flaws with the approval by silence approach, the congressional acquiescence approach. Even if we could know that Congress's current silence on a particular statutory question reflected wholehearted endorsement of that judicial decision, that is not the standard by which the Constitution confers legal effect. So let's imagine that the Congress recognizes that the judicial decision is a departure from the text, but likes the amendment. That's not how laws are amended. It's not presented to the House. The president doesn't get to weigh in. And the Supreme Court has been clear on the division of responsibility when it comes to interpreting statutes and enacting them, when it comes to amending statutes and interpreting them. And so we just can't discern much from congressional silence, even though because it works that way in interpersonal communication, there's a great temptation to read the tea leaves with Congress similarly. I'm going to conclude there. I think that's enough canards for one day. I'm happy to take some questions in the time that we have remaining. Thank you again.
We do have a little bit of time for questions. I'm going to steal the moderator's prerogative to ask the first one. So sometimes Congress enacts very broad statutes, and in some cases we might think that Congress enacts, for lack of a better phrase, common law statutes, or statutes that invite courts to engage in an iterative process of interpreting. So the Sherman Act being an example. what do we do with statutes like that? Is that an invitation to allow courts to update, say, what constitutes anti-competitive conduct over time, or should we apply the approaches you've talked about to statutes that are written in such broad terms?
That is an invitation to courts to develop common law, and the Sherman Act is the classic example of that. So the Sherman Act, by outlawing contracts, combinations, and conspiracies and restraint of trade, is written at a high level of generality. And so, as I said, textualists construe language at the level of generality at which it is written. And if a statute confers discretion, textualists are okay with that. That's Congress's choice to enact a standard rather than a precise rule. And so that is absolutely what textualists are designed to do. I'm also an evidence professor, and Federal Rule of Evidence 501 essentially tells judges to develop a common law of privilege. Textualists have no problem with that. So textualists don't have a problem with exercising discretion if a broadly worded statute gives it to them. What textualists resist is the idea that one can take determinate language and effectively transform what is a rule into a standard.
Questions for Judge Barrett? I'm sure someone has. I have more, but I'm sure.
Thank you, Judge. Very interesting lecture. I just have to make a protest, or I couldn't live with myself, that the Constitution was popular and democratically enacted, and that's a good reason to follow it. It's not a good reason to follow a document that was enacted by a racist, bigoted elite that excluded all blacks, all slaves, all Native Americans, all women, all religious minorities, and all non-property owners. It may be a good document in the way that, let's say, a piece of political philosophy is good, but it's not a good reason to follow it because 95% of the people were excluded, particularly slaveholders, Native Americans, and women who might well have thought differently. So I am shocked that anyone would think that's a good reason to follow the Constitution. It may be a good reason to follow it because it's a good document, but not by how it's enacted. That's my protest. My question here, as somebody...
I'd actually like to address your protest. So I don't think anyone says, and it's certainly, I don't want to be misunderstood to have said, that the Constitution binds us because we are somehow bound by what our predecessors did. The theory of popular sovereignty, which maintains that the Constitution is legitimate as a reflection of our popular will, derives its legitimacy not from its immoral roots. I was not eligible either, obviously, to participate in the processes which led to the ratification of the Constitution. However, the Constitution gains its acceptance and its legitimacy because we can change it. And so I'm not a political philosopher, but what the political philosophers explain is that in any ongoing society, we take the law, each generation takes the law as we find it. So an ongoing society can't reinvent itself every time. We can't, for all of us lawyers in the room, we can't throw out the entire U.S. Code, even though many of our statutes were enacted at times when processes were not open to everyone. We can't throw it all out every time. We have the choice, and we, in a continuing society, continue to accept it, and if we don't like it, we could throw it out. In fact, that's what happened with the original Constitution. The Constitutional Convention, in fact, when it convened, did not have authorization to frame a new constitution. They were there to amend the Articles of Confederation. And when they drafted and then, put into motion our Constitution that we have today, that violated the rules that the Articles of Confederation laid down for amending that document. So we, as a people in popular sovereignty, we have the authority, if we wanted to throw off the Constitution. And we have not done it because in our continuing society, we accept it, and it is legitimate because we have the authority to amend it. Now, I don't know if someone else has a question, Jonathan.
Other questions for Judge Barrett? Yes. That's Mr. Sharon. We want you to use the mic.
So I have a question about two healthcare cases, just clarifying. The first is you said that textualists sometimes disagree with each other, and I guess my question is, does textualists sometimes stop being textualists for particularly difficult opinions like King v. Burwell? And the second is, in another healthcare case, there's a clause called the direct tax clause. How do you as an originalist, there's the sophisticated user of the language, and then there's people who are intimately familiar with the abuses of English kings, both in the colonies and during the circumstances that led to the English Civil War. So how do you factor that in?
Okay, so in a couple of minutes, I don't know if those are both deep questions. Okay, so one thing I want to say about the first, like, does a textualist stop becoming a textualist when the problem gets really hard? So one of the canards I identified was that all textualists will reach the same conclusions. I could have thrown another one in, which is to say that, textualism, like adhering to textualism or adhering to originalism, is a foolproof way of making sure judges are not willful judges. Nothing can ensure that, right? So I don't want to be heard to be suggesting that, hey, if one is only a textualist, then one never oversteps. Of course, judges are human, that happens. Do I think that judges, when interpretive problems are hard, wind up in different places? Sure. So in King versus Burwell, you had none of the opinions said they were throwing over the text, right? They were all, the Chief Justice's majority opinion as well as the dissenters were all referring to the statutory text. And that's actually, I think King versus Burwell is a good illustration of the force and the influence that textualism has had, because King versus Burwell is an ideal candidate in some respects for purposivism, right? Because focusing a lot on the statutory purpose would have been very easy to do, and an opinion may well have been written that way, 30 years ago. But the opinions focused on the text, and Chief Justice Roberts focused on the text. I don't think there are easy answers, even if you're a textualist, it doesn't simplify it. So that I have to confess that I did not totally follow what your direct tax question was. Do you wanna...
I'll withdraw it.
Okay. Thank you very much.
So you mentioned textualists often disagree.
Yeah.
And there are a bunch of doctrines in the law. One that's getting a lot of attention right now is the Chevron doctrine, which are triggered by a finding of ambiguity. And some academics, like Adrian Vermeule at Harvard, have suggested that if judges applying textualism disagree, that should in and of itself be a sign of ambiguity, and therefore trigger whatever doctrines, whether it's Chevron or perhaps certain substantive canons, that we apply in the context of ambiguity. Do you find that argument persuasive? Should a instance in which textualists disagree necessarily be an indication of ambiguity, or is ambiguity itself a characteristic of a text that needs to be found on its own?
Those of you who have Professor Adler in class might want to make note of that. It could be a very good think question on an exam. I have wrestled with that question. I'm not sure. The court itself has certainly rejected the proposition that disagreement, like even disagreement among judges, even circuit splits over what particular language means, that in and of itself is, an indication or conclusive proof of ambiguity. And, Adrian Vermeule, I respect greatly, and he says that it is, and one can really one can see the appeal of that position, because if really smart people can't agree on what it means, maybe that's a sign that it doesn't have a clear meaning or a definite meaning. I'm not sure what I think about that, so I'm going to punt on the question, but I will make this observation. I think that Professor Adler's question goes to where all the action is in statutory interpretation right now. I think it used to be, at the time that Justice Scalia was first writing, that the real fight was between textualists and purposivists and this idea of whether text constrains and how it should be interpreted. And I think the ground has really shifted now to being about how do we know when text is ambiguous. Because if you have broad buy-in to the proposition that text constrains, then I think it all kind of boils down to that question, well then what does the text really mean, and how much room does the text give us to move, and what is the level of generality at which it is written? And that's obviously particularly relevant when you're talking about Chevron.
So in constitutional interpretation, originalists will at times look to the Federalist Papers in approaching a particular problem. How is that the same or different in statutory interpretation, looking at things in legislative history, like committee reports, for example?
It's so funny that you asked that question. My law clerks are going to feel so vindicated. When I was telling them about my list of canards, one of them suggested that I put that on there, and I didn't. And now he will say, "He told you should have talked about that." People would be interested. So, I mean, there are some similar. Well, it's actually more akin, I think, to looking at Madison's convention notes. So the Federalist Papers are more the equivalent of op-eds or things that were published because they were after the fact, published as think pieces and persuasive pieces when the ratification debates were underway. But Madison took secret notes at the Constitutional Convention, and so those are kind of the equivalent of legislative history of the Constitution's constitutional. They're the secret legislative history, so to speak, of the Constitution. And originalists will consult Madison's notes, and they clearly will consult the Federalist Papers, and as do interpreters of all stripes. And I think this is the difference. I mean, I don't think, so the reason why originalists will consult those things is as part of the enterprise of figuring out how skilled users of the language use those words at the time. And, Hamilton and Jay and Madison and the Federalist Papers were obviously very skilled users of the language. Even looking at the Anti-Federalist Papers, too, when you read both the Federalist Papers and the Anti-Federalist Papers, you can see, well, even though there was disagreement, everybody seemed to assume or agree that the words meant X or that the words would do X. And same for Madison's notes. And I will say this, textualists, and actually Justice Scalia himself even admitted this, textualists don't think it's illegitimate to consult legislative history. And if the reason that legislative history is being consulted is to this end that I'm describing, to figure out how skilled users of the language understood the words at the time, that's fair game. The use of legislative history to which textualists object is using the legislative history, treating it as the equivalent of the law and saying, okay, well, that's what it means and it controls solely because it appears in the committee report or whatever. And the same would hold true of Madison's notes. So an originalist would not say, oh, that's what it means because Madison's notes said that it was so. It's a data point rather than conclusive evidence, and all data points when it comes to the language are fair game.
We have time for one final question. Mr. Collins.
Thank you for a really informative and entertaining lecture. The question is, what would you as a judge do if faced with a conflict between what you would view to be the proper textualist approach to a particular problem and stare decisis if the precedent about that problem were not consistent with your textualist view?
So stare decisis actually is stronger in statutory cases than in constitutional cases. So stare decisis comes in, 3 strengths, tall, grande, and venti. And you just get regular old stare decisis for common law cases, and you get stare decisis, the doctrine says, is at its weakest in constitutional cases because the Constitution's hard to amend. But that in statutory cases, it's particularly strong. So, in statutory interpretation, as in any other kind of decision making, stare decisis, stare decisis is itself part of the law.
I think we're going to have to call it there. Please join me in thanking Judge Barrett for being here. We will have a reception.